Okay, my friends, we're testing the tubes. And it looks like they're working. That's tremendous news. Hello, my beautiful friends. What an amazing day it is. And welcome back. Very nice to see the technology connecting so that we can have a stream today. We got a good one in queue today. Bunch of business to attend to. What are we starting off with? A victory from the Western District of Pennsylvania. You can see this is an opinion that we're going to be looking at today, which is a victory for the Trump administration on the Alien Enemies Act, the AEA. And remember, a big part of this debate, can Trump issue this proclamation and deport these people afuera, out of our country? And one of the holdups on this was, well, actually, Tren de Aragua and MS-13 don't qualify as alien enemies. There wasn't actually an invasion. There wasn't actually an intrusion or predatory incursion, you know the language. And this judge came back down and said, actually, yeah, there is. We really can't second guess a lot of those decisions. And we'll read through it. A nice, good one coming out of Pennsylvania. And so we're starting to see a real big split on this. Yesterday on the show, we spent some time talking about Trump petitioning the Supreme Court, knocking on their door and saying, hello, it's been 3 weeks since we heard from you on the other cases, and that should be rectified by the Supreme Court. So we know that they want the Supreme Court to come in and resolve a lot of this. So we'll talk about that. Then we'll turn our attention to the Kilmar situation. Speaking of alien enemies, we remember Kilmar Abrego, wife beater Garcia. Well, he came up today in the congressional hearing, and we got Marjorie Taylor Greene, who got into it with Dan Goldman. They said, you know, we're going to admit this evidence into the record here in Congress. And Dan Goldman threw a hissy fit, went bananas screaming about this because he loves terrorist gangbangers. So we'll go through that. There was a lot happening today. We also had Swalwell bringing up the photo again. And we had Kristi Noem, who was answering questions about this on Fox News, representing the Trump administration. So all that's coming up. Then we'll turn our attention to what's happening with Backdoor Judge Dugan. And she and her defense team have submitted this motion to dismiss. Dugan wants the case to go bye-bye, saying that she is innocent because of judicial immunity, saying she's above the law. And this came up this morning, courtesy of our friend Economath, was saying that Judge Dugan has a solid argument that the feds arresting people in her courthouse is a violation of the Constitution, saying she's got privilege under different positions. And we'll see if those same arguments emerge. You can see Economath was sending that this morning during the members only stream, and it was a lot of fun. So that popped out. They filed a motion to dismiss. And so we'll see what that looks like, of course, here. Now, in addition to that, we'll take another look at the indictment. We did talk about this morning on the members only stream, but we'll just run through this again. We spent a lot of time on the Dugan complaint, which is the criminal complaint, but this is now just the 2-page indictment, which was signed off on by grand jurors. And grand jurors are now stamping their seal of approval on her criminality. It's not just a criminal complaint that came from an FBI special agent. It's also from a grand jury of her peers, which we'll talk about. So that's the Dugan case. Then we'll wrap it up with this impeachment situation, because this dude born in India, who's a representative who can hardly speak English, is now impeaching the president, finally submitted his articles of impeachment. And we've been waiting for this for a while. We're like, will you just do it already? You guys keep screaming about, you know, dictator and constitutional crisis and end of democracy. And then they won't even impeach him. Like, put your money where your mouth is. At least this dude, who can't even speak English hardly, is putting his money where his mouth is. And what's funny is the Democrats are like backing away slowly from this. You're like, dude, now's not the right time. Trump impeachment Republicans, I think, are pretty excited about this. They're like, yeah, no, impeach away, do it. That's why we've been saying, yeah, do it, do it. If you're so tough, just go ahead and do it if you're so concerned. And then they never did it. Now they're doing it, and the Democrats are like running away from this. So it's pretty funny. I got this queued up. The House leadership was there, and they got asked some questions on this. Like, well, you know, that's up to him, and there's a bunch of independent people in the House of Representatives, and they can do whatever they want, blah, blah, blah. So we'll go through all of that today and get into it. Now, you may notice we're not covering Diddy today. I think we got our fill and taste of Diddy yesterday. So the point is, there is an amazing individual who's covering this. Of course, you know him as Joe, Good Logic, right next door. So he's there in the courtroom, and he's going to be able to weigh in on the credibility. What did they sound like? What did they look like? Did the jury buy it? And all those details. So I'd encourage you to go check out his channel, our friend, Good Logic, right next door on YouTube and elsewhere. And he's on X covering it too. And so we'll hand it off to his good and very capable hands. I'm sure there's a lot to get into over there. So today we'll stick to this business. We had a great members only stream this morning, and we're grateful to our friends who joined us on the morning. Thank you for becoming members. You may see that sometimes this is going to pop up throughout the screen now because we're trying some new technology. You can see, boom, hey, welcome, Anthony Stokes. And of course, we'll say what's up at the end, but you might see this stuff pop up on the screen because we're checking the new systems and more. But we're excited. So we got business to attend to. Now let's get started with this nice case in the Alien Enemies Act matter, starting here. And are we coming in loud and clear? We can just confirm in that we're loud and clear. Everything's good. We've got, I think everybody's saying we're coming across loud and clear. Okay, cool. So we're on Rumble. Rumble's looking good. Hopefully. Just confirming here. Thanks for understanding. Rumble's loud and clear. Amazing. All right, so good. Very cool. All right, so without any further ado, let's get into it. Let's see. Are we stuttering? Somebody's saying we're stuttering? I got 0 frames dropped on my end. Glitches. Locals. Great on Twitch. What's up, Idiot HQ? Great to see you. Sounds good over there. All right. Hopefully it's all good. 5x5 says Chetty Mo. All right, cool. We're going to keep this train on the track. Let's go, baby. All right, here's the deal. A victory for President Trump. The AEA. Let me start that over again because I forgot to press that button. Here we go. A victory for President Trump. We see this case is coming out of the Western District of Pennsylvania, and a victory for the president is a victory for us since we elected him. We didn't elect these judges. But what has happened is in these cases, you see this one is involving ASR, and ASR is not an organization. It's an acronym for a person's name. ASR is an individual who doesn't want to get deported and is suing the government essentially to say, you can't have lawful detention over me. You can't deport me by invoking the Alien Enemies Act. And what we've seen here is judges all across the country have found little justifications to find in their favor, certifying them as class action gangbangers, saying that they're not getting proper due process, basically holding Trump in contempt, ordering discovery, and just kind of mucking the whole thing up. Even the Supreme Court has issued a stay and ordered Trump to stop the removals of a lot of these people. But now this decision comes out of Pennsylvania, and this judge gets it right finally. And we're going to see, I think, a lot more of this as the forum shopping starts to dissipate. Remember, they went and picked the most favorable judges for them to give them the rulings that they wanted. And now we're seeing some actual legal logic start to bubble up. So here is what is happening here. The person who is in this case is called ASR. This is a Venezuelan man who's an illegal, currently in immigration custody. And they say he's subject to the AEA, Alien Enemies Act. He's got to go. Now, he has requested that this court in Pennsylvania say these three things. One, that Trump's proclamation is not in alignment with the Alien Enemies Act. Okay, so Trump came out, issued an order, and that order is out of the law. The law Alien Enemies Act was passed by Congress. It says you can use it for these things. Trump is not using it for those things. Therefore, it is unlawful. They also want to say that the due process is currently insufficient. And so that's generally what the Supreme Court has told us, is notice and opportunity to be heard. Okay. Do you have notice of what's happening to you so you can challenge it? And is there an actual opportunity to do something about it? So they want a lot more due process, and the judge is going to find in their favor a little bit more on that one. But the big one is this first attempt here, right? This would invalidate Trump's entire proclamation is the theory. And then they want other relief. Now, the judge writes this. This case, the Alien Enemies Act, it poses significant issues to our country and to us that are deeply interwoven with the constitutional principles upon our founding. And so we have to begin by stressing stuff that we are not resolving right now, right? It's a very prickly position. Now, this court is not resolving the question of whether the president may direct the removal of certain people. And the court is not resolving the question of whether the president, okay, so kind of making a Venn diagram, kicking the president outside of that, because we have a real separation of powers problem if the judge is ordering the president to do anything, as you can imagine. And the court is not resolving a lot of those things. And third, the court is not resolving the question of whether individuals who are subject to removal are entitled to notice. Okay, like that's already been decided. The Supreme Court has said you already are entitled to notice, right? SCOTUS said that. We were always fine with that. You're entitled to notice and an opportunity to be heard, and you can go file in habeas in Texas. They didn't want to do that, though. They wanted class action gangbangers in Judge Zenas' courtroom. Instead, the question the court is going to answer here is this. So long as the government gives sufficient notice and due process, may the president issue a proclamation under the AEA doing what he did, right? Venezuelans, 14 or older, in the United States, neither actually naturalized or lawful permanent residents, so they've got no lawful status to be here, who are members of Tren de Aragua, which is a foreign terrorist organization. So can the president do that? That's all we're asking. And after extensive consideration, the judge says, drum roll, the court answers the question in the affirmative. Can the president do that? Yes. May he issue a proclamation? Yes. Obviously, he's the president. So therefore, the judge explains in detail. Because this court finds that the president can do this, the court denies their request for an injunction. Now, the court does say that you do need more notice, essentially. The notice, right? You got to give them a little bit more sufficient notice. And so accordingly, we'll make you do that. Now, here's the background, right? We know what the AEA says. It says the president may make a public proclamation, predatory incursion, enemy invasion. And that is exactly what Trump did. On March 14th, boom, comes into the White House, says we're taking care of business, TCB. Says Tren de Aragua is closely aligned with and has infiltrated the Maduro regime, and they're terrorizing our country, right? There's the whole proclamation there for the record. Writing, as a result of the foregoing, Trump found that TDA is perpetrating, attempting, and threatening an invasion or predatory incursion, right? Those are those legal terms of art. They're going to say, for, many different parts of the statute they're going to challenge. Oh, they're not enemies. They're not like labeled enemy combatants with an enemy uniform on, carrying an enemy flag. No. It's a little different than that, but they would want you to have a much more narrow definition of who qualifies. Explaining, Trump concluded these things and wrote it into the proclamation. Now, the court is going to give us an overview of the law. It says, well, the Secretary of State can come out and do these things. And as the Supreme Court has explained, national security means a bunch of stuff, things like national defense, foreign relations, economic interests, and more. And an entity that is designated a terrorist organization, they can challenge that, okay? Like if Tren de Aragua says, hey, wait a minute, we're not gangbangers. We just are innocent pupusa bakers. How dare you? Well, then they can challenge that, okay? The law says they can go to the DC circuit and they can challenge that. If they say that we're not actual terrorists, there's a mechanism. I did not know this. This is hilarious. The gangbangers just go sue. We're officially, who are you a lawyer with? The ACLU would probably represent them since they're basically an extension of Tren de Aragua anyways at this moment. So just go sue. Just say, no, we're not. We're not a terrorist organization. They didn't do that. And there's a bunch of procedures. And Congress can also have a remedy on this too, right? So there's a bunch of stuff they can do. The DC Circuit can hold a designation unlawful if it's arbitrary, capricious, contrary to the constitutional power, in excess of statutory jurisdiction, lacking substantial support, not in accordance with procedures, and more. And Congress can also override that. If you say, hey, Tren's a terrorist group, foreign terrorist organization, Congress can say, no, they're not. So on February 20th, Rubio also found that Tren and 7 other organizations were FTOs. Bunch of them. Tren de Aragua, Mara Salvatrucha, Cartel de Sinaloa, Jalisco, Unidos, all of them. They're all on the list. And the record, writes the judge, supports the evidence. We also have 2 declarations that Trump submitted. The first is a declaration by this person called Selwyn Smith. This person's Deputy Assistant Director, aka DAD, for Homeland Security. His acronym is Dad Smith. And Selwyn, is that a dude? All right. So in Dad Smith's declaration, he provides significant background based on his personal knowledge and experience. He says, oh yeah, no, TDA, Tren de Aragua, their growth, their spread throughout the United States is rampant. Members are involved in illicit activity. They invoke fear and supremacy in neighborhoods. They take over Denver apartment buildings. They traffic women from Venezuela. They commit bank fraud, narcotics frauds. They traffic human beings, homicide, many other things. And they are now present in the United States, committing criminal activity in 40 states across our country and in Canada. And Dad explained that the NYPD recorded a surge in robberies that they believe are happening by TDA recruits, right? You got to go commit these robberies if you want to be in our gang. Now, accused leaders of this group have also admitted they've got a complex network in Florida and Texas, and they ship their profits back to South America. And crews of the Tren de Aragua network are also involved in extortion and ransom schemes and more. This guy says they pose an extraordinary threat to the American public. Obviously. Now, the second is a declaration by Michael Kozak, and he's a senior bureau official from the Western Hemisphere. He said in his declaration that he's also got extensive work in Venezuela and elsewhere. And according to him, he says U.S. government officials from the White House and the State Department have negotiated at the highest levels with the government of El Salvador with Maduro and his representatives in recent weeks for those countries to consent to the removal to Venezuela and El Salvador, some of the Tren de Aragua members. Kozak says, actually, yeah, we reached agreements to this effect so that foreign interlocutors would accept the removal of some of the Tren gangbangers. These arrangements were the results of intensive negotiations between the United States and El Salvador, and there were also representatives there of the Maduro regime. Right, so we've got MS-13 and Tren de Aragua, and we got to keep them separate. MS-13 is the Kilmar case in El Salvador, Tren in Venezuela. Now, against this backdrop, the judge says, so that sounds like pretty good evidence, right? We've got 2 declarations from government officials who are all saying that this has to be considered. It's a real threat to the country. Here's why. Now, against this backdrop, the court turns its attention to the factual and procedural history of this case. Now, there's a big question over jurisdiction, and it eats up a lot of time. So we'll go through this quickly. But does this court have jurisdiction at all? This has actually been a big issue because of habeas, right? And the Supreme Court saying, Judge Boasberg, you don't have jurisdiction. You have to send this back to where they're being housed. That happened to be Texas. What happens in Texas is not favorable to them, which is why they want to keep it in D.C., where they have all their favorite judges. So the judge is going to walk us through this. Says, all right, listen, here's what happened. On April 15th, not long ago, this person filed a petition. Now, on that same day, he filed a TRO. So files this by himself, habeas petition, right? Which we've never been opposed to. Neither has the DOJ. It's always been appropriate. Yeah, if you want to individually file, because you say this is wrong, go for it. But you don't get to be certified as a class and then file a constitutional claim that then that invalidates the entire proclamation everywhere across the country. Are you crazy? So he did that, right? He files his habeas, and then I don't know if he's got the ACLU lawyers or whomever on his case, but then they file the TRO, which the judges grant as the injunction, and then the motion for class certification. So then we get class counsel, which is going to be the ACLU gangbangers, right? Because they got appointed for the entire class by other judges. Now, this illegal represents, he says, you know, at the time he filed his petition, he says, I'm a Venezuelan man, probably a barber or a PhD philosopher or makeup artist or something. He says, I'm at imminent risk of removal. Now, along with his petition, he also submitted a declaration from his gangbang lawyer. Now, in that declaration, the lawyer made the following statements. They said, hey, I'm a gangbanger lawyer, and on April 14th, he was detained here. He's a citizen of Venezuela, born in 95. He was put on the intensive supervision appearance program. During that time, ICE arrested him and told him his neighbor reported him. Neighbor called, said, "You're a member of Tren de Aragua." Neighbor called him in. ICE asked him about his tattoos. Oh, ICE filed an I-213 accusing him of being affiliated with TDA. Now, while he was detained at MVPC, this is the lawyer speaking, he was in pending immigration removal proceedings with an immigration hearing scheduled in Elizabeth Immigration Court, so it sounds like parallel things happening, right? He's got two different bases for removal. One, Alien Enemy Act, being Tren de Aragua. The other, he's just an illegal. ASR denies that his tattoos are connected to Tren. He vehemently denies any connection to that organization. No, clearly, and we all know they're just tattoos to remember his auntie who died when he was a boy. Yeah. Finally, according to his counsel, his lawyer, it appeared that he was at grave risk of removal because he's TDA. So then on April 15th, this court entered a TRO, temporarily stopping his removal. Said, all right, we don't know. Let me hold up. Judge paused everything. Said, okay, we'll come back for a hearing on April 18th. Then on that date, before that, the court was notified that they transferred this dude to Texas, right? So they then moved him. So she's going to say, okay, you moved him, but I had the case before you moved him. The government also submitted a declaration. Yep, we moved him from Pennsylvania to Texas. The court then held a status conference, and the government would have said, well, you don't have jurisdiction anymore because we moved him. She's like, no. After receiving briefs, everyone agreed that he was present when he filed. He's no longer there today. And because he was there when he filed, the court has jurisdiction. So the court held that the TRO would remain in effect, right? So everything would be paused. And it said, don't remove him from the country. Keep him down there, but he's got to get notice in English and Spanish. And he's got to have interpreters if they need them. And, red carpet, ACLU lawyers and all the things, because they get more rights than you, because they're better than you, according to our own government. Now, finally, the court informed ASR he was permitted to file a motion, and if he did, we'd have a hearing. So then we had another hearing, and it was about certifying a class. And the court notes there's going to be a separate opinion on that and more. Now, then they filed their response, and the reply came in, and then we conducted the hearing. Now, during that hearing, two things occurred that are especially relevant here. With respect to jurisdiction and standing, counsel for Trump indicated that he could not guarantee this court with absolute certainty that the government will not deem ASR to be subject to removal in the future. Say, like, we can't say that. There might be some other proclamation. He might come under it in the future. And second, with respect to notice, they said, we're currently giving 12 hours of notice, right? They're like, okay, that's not long enough. They say, well, 12 hours, they get notice and they can file or not. Otherwise, they're getting on a plane. Okay, it's like, midnight, you're leaving at lunch. So here you go. Here's your notice. Get a lawyer or you're out. If an individual indicates that he wants to file, then he gets another 24 hours. And if he does file, then they won't remove him. So this court begins by asking these basic questions. Do we have jurisdiction over this case? She's going to find, yes, we do, and make a ruling. As the Supreme Court says, federal habeas gives district courts jurisdiction where they're in custody. Now, even though you moved this guy, he was here and then moved. He was scheduled for an immigration hearing in New Jersey on April 15th for another reason, right? So this kind of complicates things because he was also being processed under the INA. So think about it like two separate tracks or like two separate almost crimes or prosecutions, right? Both leading to removal. But the INA is just regular immigration stuff because he's not lawfully here. And then the Alien Enemies Act is Trump's new proclamation. So if I take those both together, the court is left with the following question. She's like, gosh, if he has always been in custody under the INA rather than the AEA, right? Because then Trump is saying, actually, when we had him in custody under the INA, which is over here. So that's why we moved him. So you actually never had jurisdiction. They filed in the wrong spot. They said, well, if that's true, if he was in New Jersey, then why'd you move him to Texas? The court can't square this circle. And it seems like his abrupt movement is evidence that he was then in custody. So she's just going to say, I find that anything else, right? I have power over this guy. The evidence to which they cite does not say that they determined that he was not removable under the proclamation. And in short, while the court has before it indications that he was in custody under the INA, which they're not suing under, the court finds that to believe those representations would be to exalt form over fairly significant evidentiary substance. And so the court is going to find that on April 15th, when he actually filed his habeas petition, he was in custody pursuant to the proclamation and the AEA, right? So I think you could probably split hairs on that. And she's just going to find in favor. She's ultimately going to give us the outcome that we want, so it's not really consequential. Accordingly, this court had jurisdiction over him and finds that even if they did move him from removal proceedings or to removal proceedings under the ANA, right? So, okay, well, we got this guy under the AEA, but now we're not going to use that. We're just going to use the INA and drop that other case. Like we got this guy for, possession of narcotics, but we also got him for possession of dangerous drugs, right? And some other classification of drugs. And so then you just pick one, drop the other, pursue that claim, and that's your discretion to do that. She says, well, you might, but I'm just going to hold that you had him basically in custody for both reasons, and the fact that he filed this while he was in custody gives me jurisdiction over it, and I'm going to liberally construe the custody requirement for habeas. And so now it's about standing. Do they have the ability to sue? The court finds that, yes, he does have standing. He was personally facing removal. And Trump is kind of saying, well, we're not actually subjecting him to the AEA, though. Now we're just going to use the INA, not the AEA. She says, well, if we assume that he's no longer subject to the AEA, then we have to ask whether mootness applies and more, whether this could come back, right? She's like, well, if I dismiss this, this is capable of repetition yet evading review, which is this concept that you don't want this to come back, right? Because then Trump could do this every time, kind of like file something and then change his strategy and then dismiss it. And then the court will be like, well, I still want to rule on that case. So since you could do this and evade review, I'm going to hold on to it and make a decision about it. Now, on April 7th, she writes, the Supreme Court heard an appeal regarding Trump's proclamation, and they said that individuals subject to removal had to have judicial review or could have judicial review as to the interpretation and the constitutionality of the act, right? So the Supreme Court came back down and said, judicial review of this act is limited. Judges can't just come in here and say, well, actually, Trump shouldn't have done that, or Trump, this was a bad decision because I'm the judge and I think it's smarter if we do it this way. Well, you're not the president. You don't get to make those decisions. So the Supreme Court noted, it is limited. You can't substitute your opinion, but if you are subject to removal, you do get some limited judicial review. Of course, maybe the interpretation and the constitutionality of the act. Like what if Trump came out and said, all lawyers are enemies of the state, and you're all going to be deported of this country because I hate lawyers or something, right? The courts would probably come back out and say, well, you can't just codify that group of people as alien enemies. There's no evidence of that. And so they would find that proclamation to be invalid. Generally speaking, right? Now, because you might say that's arbitrary and capricious. Now, if Trump, in this case, right, has a bunch of evidence and declarations from other people that say, yeah, Tren de Arag was pretty bad. MS-13 is pretty bad. Then you can't question that judgment. So it's kind of a different, I would say, scope, magnitude, and it's that line of arbitrary and capriciousness, and where do you reach that? But here, does it apply? Are you 14 years of age and older? And here's what this judge finds on that basis. Says clearly, based on this statement, the court can interpret some of this, the meaning and the words of the terms within the AEA. For example, what does invasion actually mean? What does predatory incursion actually mean? And this court may also consider questions like, is notice appropriate and more? They said reasonable time in the Supreme Court that actually allows them to seek habeas in the proper court. And the court also may theoretically assess the constitutionality of the AEA. And although the issue is well settled in favor of the act, the court may assess, is the individual subject to the AEA? A question that they're not presently pressing upon this court because that's in habeas, right? That should be filed elsewhere. Now here, they tell us. However, the judge says, this illegal wants a more intensive inquiry. When he says that Trump and his proclamation cannot survive and must be declared illegal because they are simply incorrect as a factual matter, right? There is no predatory incursion argument. There is no invasion argument. Tren de Aragua is not an alien enemy. And here's what this judge says. You've invited me to make that assessment, but I'm going to decline to do that. Not going to happen. The court first notes that in the JGG case that went up to the Supreme Court, it doesn't give me permission for this court or any court to weigh the truthfulness of the factual representations within the presidential proclamation. Trump said this is happening. The judge can't say, actually, no, it's not, because I read CNN and Jake Tapper told me so. You don't get the right to say that, Judge. He's the president. You're not in a position to do that. Noting that judicial review is limited and the proper subjects are interpretation, constitutionality, is an individual, in fact, an alien enemy, and more. And in another Supreme Court, they also expressed hesitancy to wade into weighing whether a state of war even existed. That's not for the judges to decide. A reality that triggered the declared war component of the AEA and permitted the president to use the act. They can't substitute their judgment for that. Now, in this same vein, the district court for the Southern District of Texas that we talked about yesterday recently concluded that after a court construes the meaning of these terms like invasion or predatory incursion, it's up to the executive branch to determine whether that has occurred. Now, as to this decision, the court may not delve into whether the executive branch possesses sufficient support for its conclusion. Well, Trump should have done a more strenuous analysis on Tren de Aragua. Or whether the court agrees. You don't get to make those interpretations. That analysis would require the executive branch to disclose to the court the undergirds of a finding of what a predatory incursion is. And that is contrary to the law. They're not required to answer to you before they make those decisions. Before leaving this subject, this judge says, the court also notes, the Southern District of Texas also concluded that the presidential declaration invoking the AEA must have sufficient factual statements so that the court can make a decision. Now, you don't have to disclose everything, but you got to give the court enough to say, okay, like that's good enough. That meets the standard. Now, this articulation of the law appears reasonable, appears correct to me, says the judge. And as the court finds below, Trump's proclamation meets this standard. It's lawful. Therefore, the court doesn't need to spend extensive time working out the nuances of any of this. They did it in Texas. And the court assumes, without deciding, that the Southern District of Texas is correct on this issue and proceeds accordingly. And so now let's get into the law. Of course, we know what the standards are for a preliminary injunction. One of those standards is the party who wants the court to do something, are they going to win on the merits? Are they going to win the case? When interpreting a statute, the court's job is to look at the ordinary meaning at the time Congress enacted the statute. And we can look to dictionaries and more. Now, in the context of a constitutional rights, we have to look to ways of interpreting what the law says. Now, what happens here is that Trump says, here's the meaning. A predatory incursion, like what Tren de Aragua and the AEA is doing, under the AEA means entry into the United States, that's all, for the purpose that are contrary to the interest or the laws of the United States. That's it. That's Trump's elements. Just going to check those two boxes, and that's going to be it. Now, the court deems that definition deficient. Okay, she's like, it's not big enough. Somebody came in and it's contrary to our interests, like that's all. The judge says, well, it's not really good enough there, Trump. But here's what I'll find. The court's basis for this finding is rooted in the dictionary definition of the words. What does predatory mean? What does incursion mean? If you look back to a 1773 dictionary, predatory means plundering or practicing rapine. Hungry, preying, rapacious, ravenous. The same dictionary defines incursion as attack, mischievous, occurrence, invasion without conquest, inroad, ravage. In 1828, predatory meant plundering, pillaging. It also said predatory war was like a predatory party. predatory spirits or appetites. They define incursion and other definitions. Now, the court pauses here and says, first of all, this is interesting. So Trump says this, the definitions say this. There's at least two characteristics that I'm seeing in these words that we're not seeing in Trump's definition. First, they speak of a cohesive unit. So it's like a group of something entering for a united purpose. Now, Trump's definition is deficient, as Trump's definition could apply to a single person. Like there's no collective element to that. And second, these definitions indicate that incursion was commonly referred to military activity back in 1798. Now, their definition is also sufficient because it doesn't account for common and significant destructive purpose for which a cohesive unit must enter. Okay, that's what a predatory incursion is. So the judge says, oh, that's complicated. Now, our initial observations about the meaning of predatory and incursion are confirmed by the use of those words back in 1798, telling us, in 1805, the Supreme Court referred to hostile incursions at the hands of Indian tribes within the context of war. Now, this action was taken by a cohesive unit. They had entering a territory. So like, just think of these like checkbox, got that one. Entered a territory, common and significant destructive purpose. Okay, so check the boxes. And the Supreme Court also quoted a charter in 1832 to William Penn of Pennsylvania containing the following language. He said this, because in so remote a country near so many barbarous nations, the incursions, as well as the savages themselves, as other enemies, pirates and robbers, may probably be feared. And finally, based on its extensive consideration of other cases in 1798, Texas also found an incursion referenced the military force or an armed, organized force that came in to plunder your booty with the subsequent retreat. So therefore, the court says, well, Trump's definition doesn't really get to the AEA. Okay, migration alone. So somebody just coming across, it's like contrary to our interest because we don't want illegals here. That alone is not enough as a predatory incursion. But the proposed definition would lead to certain migration alones qualifying, and that's not what it's for. But so if that definition doesn't work, what about the other definition? So the other side, ASR, the illegal, and his gangbang lawyers, right? Well, they say it has to be very specific. Like it has to be a military action by a foreign government. So their checkboxes, it has to be military, like probably in tanks with bazookas, by a foreign government officially in uniform that constitutes or precedes an act of war. It's like, okay, so basically we would never have one of those unless it was an act of war. So why are we just going to war then? Like if they're going to do that, are we just going to declare war on them? What's the difference? They say, mass illegal immigration, criminal activities, gangbangers, that's not what the law's for. And the court agrees with some of this. They say that the predatory incursion does require a cohesive unit coming in. Migration alone is not there. But the recount from this gangbanger illegal of the proclamation suffers from one defect. It omits the fact that here, the court is not dealing with mass illegal immigration or criminal activities. They've been designated terrorists. Hello. And they did it through the legal process. Now, the fact has been weighing heavily on this court. They're terrorists. They're not just regular criminals. To reiterate, the Secretary of State may only designate terrorists when they engage in terrorist activity. And when that happens in the United States under the law. And an FTO, if you are a terrorist organization, you can sue. You can seek extensive judicial review, and Congress can reverse that. Maybe go to Senator Chris Van Hollen. All right. And he'll tell you, these are good people who are in our country for a better life. In light of the after they beat their spouses and traffic illegals, in light of the foregoing, the judge says, coupled with the fact that the Supreme Court has considered a statute's mixed meaning, a meaning as fixed, but its application subject to change, the court must ask another question. Is a duly designated terrorist organization that meets the law, and if that person enters the United States to destabilize, is that not the very definition of this? Is such a terrorist organization not the modern equivalent of enemies, pirates, and robbers committing incursions, just like back in 1798? And those of you who've been with us for a couple weeks have said, well, we've been waiting for this, right? All of the terror analogs are going to come back out. Because if you can say, terrorist isn't this amorphous term that we can use to do a bunch of stuff, like including spying on our own people, and violating our Fourth Amendment rights and issuing FISA courts and all these things, then how can you carve out kind of an exception to terrorism for these terrorists? It's like totally illogical. This judge is asking that same question. It's basically the same. Like it's morphed into terrorism. So there's case law out the wazoo supporting this back during the post 9/11 stuff. So first, the AEA, she says, does not require that an invasion or incursion be perpetrated by the military of a foreign government. That's not in the law. The words are not present in the text, and the word military is not in there at all. So if predatory incursion requires a military, that must come from the word predatory incursion as of 1798 and not from the statute, and it's not in there. Now, in second, the word terrorist and terrorism were not in any significant use in 1798. Neither of the dictionaries even had that word. Further, based on the court's review, the first word terrorist was back in 1941. And the first use of terrorism that the court could locate was back in 1880. Since those words were not even in significant use under the AEA, we can't really make an equation between the two, right? Predatory incursion is an analog to terrorist activities because they already knew how to declare war, right? They already had that in the Constitution. That was a known tactic. Now, third, modern definitions of predatory incursion also match the definitions back then. The current definition is plunder, pillage, inclined to injure, personal gain or growth, Merriam-Webster's, a hostile entrance into a territory like a raid. An incursion is into enemy airspace and more. So at this juncture, the court invites the reader, that's us, to turn to the preceding subsection and reread that. No, but we got the point. And fourth, she says they're basically the same, right? It's predatory incursion is fairly being applied to terrorist organizations. It was this kind of catch-all for these other groups of bandits and robbers and pirates plundering booty. Now, fourth, as the terms terrorist and terrorism has become more common, courts around the country have used incursion in ways that support this. For example, in 1873, the courts recounted how carriers were sued for the loss of gold. In 1961, there was another case. In 1992, in 2013, bunch of these examples. So to recap, the word military is not found in the AEA. So it's not a military entity. Terrorist and terrorism weren't even used back then, and predatory and incursion have similar definitions as they do today. Terror organizations are repeatedly referenced in case law as predatory groups, and there are cohesive groups that have a common and significant destructive purpose. Check, 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 check. So in sum, based on the Supreme Court's statement that while the meaning of the statute is fixed, new applications may arise, and this court has continued to ask itself, if terrorist organizations existed and were entering the country back in 1798, would the public and the Congress back then have viewed these as incursions? Yes, of course they would. They would call those predatory incursions. If we had Tren de Aragua attacking George Washington's family. Now, the Supreme Court respects the conclusion of the political branches in the realms of national security, since, that's their job. And therefore, the court rejects the gangbangers' use and definition of predatory incursion. And so, in light of all of this, Trump's proclamation got it right. And we reach the following definition of predatory incursion. Here's the judge's definition. We'll see if this catches. It is a hostile entry into the United States, Tren, MS-13, by a cohesive group of individuals in a gang, such as a military detachment or an FTO, who are united by a common goal of causing significant disruption to the public safety, whether people, property, or pecuniary interests of those in the United States. So she just kind of cobbled that together and said, I think that's an appropriate definition based on my interpretation. And the court finds that is meaning and faithful to the meaning of what they wanted back in 1798. And there's a new application, which is applying that to terrorism. And when this court does that and applies Trump's proclamation to its finding that Tren is committing a predatory incursion, They follow the law. The proclamation and the declarations provide a factual basis. You might disagree with the factual basis, but they provided it. Secretary of State designated it. The law heavily supports conclusions that within the proclamation that TDA is a cohesive group. And there's other declarations that have been submitted. And further, this court also finds that the documents that are referenced by the proclamation support the finding that there is an incursion. There's a common disruption, common safety, just like in other cases. There are military detachments and pirates around the time back when Congress enacted this in 1798. And now this entity is designated an FTO. They're hell-bent on destabilizing the U.S. They're flooding the United States with illegal narcotics. They're using the drugs as a weapon against our people. And all of that meets the requirements. And so for the foregoing reasons, this judge says the proclamation meets the definition, and the illegal has not shown a likelihood that they're going to win on this matter. And it also satisfies this checkbox of being against the United States. The AEA also says it has to be against the territory of the United States. And the illegal says, well, that means it has to be a military. The court has already explained why that's not right. Against the United States is much broader than just a military attack. And turning finally to the phrase a foreign nation or government, saying we're going to afford substantial deference to the conclusions of the president on this. This is a sensitive and weighty issue of national security. The deference is mandated by the Supreme Court. It's due to the fact that neither members of the Supreme Court nor judges get the daily briefings. They don't get any new information. And so they're not in a good position to make a good judgment. The court also notes it's not our power. The president alone has the power to make these determinations. And so therefore, the court will accept as true Trump's conclusion via the proclamation that Tren is acting at the direction of the Maduro regime. And now, based on this conclusion, the court is in full accord with Southern District of Texas. They say the same thing. They say, although the proclamation in Texas focuses on TDA's activities, it places control of those activities in Maduro, and it declares Venezuela, through Maduro, directs Tren in America and concludes they're responsible for that. Now, you might disagree with that determination, but you're a judge and you don't have the information to make that decision. So you don't get to substitute your analysis. If the people think that's wrong or Congress thinks that's wrong, they can do something to reverse that. But under the law, it meets the requirement. So in light of the foregoing, the court finds that Trump's proclamation complies with the law, and therefore we turn our attention to the notice that is being provided, right? So this is where the judge is going to throw them a bone. Says, now, while the respondents say that the ASR is not being detained to the AEA because they're being detained under the INA, we do want due process in terms of notice to be provided. The Supreme Court has held that detainees are entitled to notice and an opportunity to be heard that's appropriate to the nature of their case. In this case, it's habeas. And they have to actually be able to seek it. Now, far in excess of the notice requirements, this court said that 14 days meets due process. But when the court reached that decision, it also certified a class, and the court was of the mind 14 days was sufficient. But now, because the court finds the legal requirements of a class are no longer satisfied, the court must also consider how much notice is appropriate absent class certification, right? So this is like a double dip. They lose on the AEA and they lose class certifications. But when the court conducts that inquiry, the court says 21 days notice is an adequate time. First, the court is intimately familiar with ICE proceedings and the region. And so we know that they're moved a lot and they need an opportunity. So 3 weeks. Now, further, pursuant to the Supreme Court's admonishment that they're notified of removal, the court will continue to require they get it in English and Spanish or whatever language, and they get interpreters if needed. Finally, with respect to this particular case, because this guy has a lawyer, he gets notice on everything as well. And if he wants to challenge it, he can file individually. But their other arguments are unavailing, and they lose on those. They say it's fundamental that Trump found all members are, by virtue of their membership as Tren, hostile to the United States, and there's a finding of factual support here for that. And he does not need to give them an opportunity to deport prior to removal, right? So he doesn't have to give them an opportunity to self-deport. If they want to self-deport because they don't want to go to CCOT, that's their prerogative. They should leave now. Second, they also say that Congress wanted the INA to supersede all of their previous laws, and she says, no, I can't find that either, saying, in light of all the foregoing, the court denies the motion for an injunction on all of the major issues. Now, as the court explained above, the Supreme Court has explained that there are other remedies here, and there's not going to be any additional harm on this. And so, in conclusion, the judge, Stephanie L. Haynes, writes the following. As the court stressed at the very beginning of this case implicates significant issues, and in resolving those issues, this court's unflagging obligation is to apply the law as written. And when the court does so, it finds that Trump's proclamation complies with the law, and also finds that Trump must provide greater notice, give him 3 weeks. But having done its job, the court now leaves it to the political branches of the government and ultimately to the people who elect those individuals to decide whether those laws and those executing them continue to reflect their will. Great decision from Judge Stephanie Haynes, U.S. District Court judge here, saying, look, man, she might even disagree with this. But they're not actually, a big threat or whatever. But Trump checked the boxes, and they don't get to substitute their judgment because they're not accountable to the people. Trump is. His administration is. Rubio is. If the American people are mad about this, they can speak to their representatives and they can impeach all these people and remove them. But they know that the people are happy with this, which is why the hack judges, who are not Stephanie, are doing everything they can to insurrect the operation of the executive branch. But Stephanie Haynes, district court judge, delivers a nice victory to the president. And now we've got 2 cases now. The other one in Texas is joining this one. We're starting to see victories consolidate. We're going to be here continuing to cover this case and more. Thank you for subscribing and joining as we do. All right, now let's keep this train on the track because we had a spicy moment in Congress today. And here is what that one sounded like. A blowout in Congress today. Marjorie Taylor Greene getting into it with this person you see here, Dan Goldman, on the right side of your screen, who is very in love with illegal gangbangers. And the moment that Kristi Noem was testifying and the moment that Marjorie Taylor Greene wanted to just add into the record some evidence of Kilmar's gangbanging ways, Dan Goldman lost it. And in addition to that, we've got more clips from Stinky Eric Swalwell, who made Bang Bang with Fang Fang, also getting into this on behalf of gangbangers, and more reaction from Kristi Noem, so stick around. But here is what happened today in Congress when this went off the rails.
People are hurt on your watch.
Gentleman's time has expired. I now recognize...
Mr. Chairman, sorry. I ask unanimous consent to enter for the record. One of our colleagues had asked if there was evidence if the so-called Maryland man, Kilmar Abrego Garcia, was MS-13. According to the Attorney General of the United States, she posted that the evidence shows Kilmar Abrego Garcia has repeatedly been identified as a member of MS-13 by a Maryland County Police Gang unit, which I introduced for the record, a reliable confidential informant, ICE officers, an immigration judge agreed, and an appellate board agreed.
Without
So you have, is that a court order?
Objection.
Well, I object.
No, she can put anything she wants in the record. She's not complying to your request, Mr. Goldman.
She asked for unanimous consent.
Okay, so you're objecting to her putting that into the record?
I am objecting subject to a clarification. Is that a court order that establishes that he's a member of MS-13?
An immigration judge agreed that he was MS-13.
For bail
An
purposes.
appellate board agreed.
Don't misrepresent.
Hold on.
A judge.
Everybody pause. We're going to let one person talk at a time. You ask a question. Answer the question, please.
According to the Attorney General of the United States, she informed the country that an immigration judge agreed that your Maryland man, Kilmar Abrego Garcia, is MS-13. An appellate board agreed. ICE officers
are misstating
agreed.
what the
reliable.
Nope, it's not a misstatement there, Dan. It was found in writing. You can read the opinion. He appealed it, said, I'm not actually MS-13, and they denied that appeal, and it is written in a court document. So he's already had due process on that issue. It's already been adjudicated. He doesn't need to have another hearing on that again.
Mr. Goldman, the clock is not yours right now. She has the floor.
Pipe down,
Please
Dan.
continue answering the question.
Thank you, Mr. Chairman. A Maryland County
She's not answering the question, sir.
No, she's going to answer the question, and then you can object to her answer.
Make sure that she answers the question?
Finish answer. You just said, please finish your answer.
A Maryland County Police gang unit agreed that he's MS-13. A reliable confidential informant agreed that he's MS-13. ICE officers agreed that he's MS-13. An immigration judge agreed that he's MS-13. An appellate board agreed that Kilmar Abrego Garcia, your Maryland man, is MS-13.
Okay.
I
You have
object.
the floor. What do you want to say?
I object because she is misstating the record and the facts. That is not accurate, and
Yes, it
therefore I
is.
object to that being introduced. There's no.
Mr.
Well, sir, can
Chairman?
I explain? You let her go on.
Go ahead.
There is no final court order establishing that he's a member. Maybe he is.
What does that even mean? It's written in a court order that validates his removal. So he wants to have like a trial on it? Is that what he wants? Like a conviction?
So you should put all that evidence before a judge, and if he is MS-13, he should be deported. That's what we're talking about, but you're misstating what all of that evidence is.
No, I think I'm going to make a point here. You basically just read what the Attorney General said, correct?
Yes, sir.
You didn't assert that this was a court order, did you? Did you assert that this was a court order?
I read
It is a court
Attorney
order.
General of the United States.
And you have a right on our committee to submit for unanimous consent or a vote, if we want to put it to a vote. This for the record, correct? Is that it?
Yes.
That is correct. Okay,
Mr. Chairman,
she has a right.
Can I review what she is submitting?
No, she can submit something to this committee.
But it matters that she just said she represented exactly what the Attorney General said. She has a document there. I would like to see that document.
Let's make a copy
to
for
see if her
everybody,
representation-
and we'll vote on. I'm going to hold on just a second. We're going to hold. You're calling for the question? We're calling for the question. The clerk, we're going to need to set. Hold on just a second. Brief recess.
Please, let's get these on this.
Okay, while they're figuring this out, we'll come back to that. But we've talked about this. There are many court orders, and you can access them at watcherlodge.com in the Kilmar section, where we've got them listed there for everybody to read, including Dan Goldman, because apparently he can't figure it out. But when you go over to the lodge and you take a look at the Kilmar section, all of the court documents are there. And first of all, the withholding of removal was adjudicated to Guatemala, as we pointed out many times here. Dan doesn't want to talk about that either. But we had all of the orders right here. Kilmar's appeal is right here. He is not somebody who should not be removed. Removable is his status, and that was all denied. And in that petition, in those documents, the court found his claims that he's not MS-13 were not reliable. So Goldman is still trying to fight for illegals for whatever reason, and they took a brief recess over there
To vote.
and then they came back, and here is what that sounded like.
All right, there's
Mr. Higgins, I'm just asking
hold
to
on.
see the document.
I have the floor. All right, so we have a motion to vote on the submission of this for the record. That's all that has been stated. And
I have a parliamentary inquiry, sir.
Do not interrupt me again.
Punk!
We are on the vote on whether or not this can be entered into the record. A motion has been made, and we will vote on that motion. All of those in
I have
favor.
a parliamentary inquiry before we vote, sir.
Mr. Ranking Member.
It's our request that we object. And in the middle of the objection, you consider a motion, which...
He was done talking about Ms.
No, he wasn't. No, he wasn't. You stopped him from talking.
I just have a parliamentary inquiry.
A parliamentary inquiry. Okay, go ahead. You have the floor.
Is it the procedure of this committee that someone who is making an objection to the admission of evidence cannot review that evidence before we vote on it?
Yeah, the content is irrelevant to the motion, and the motion has been made to vote on the submission for the record.
The content is irrelevant? I mean, that's what I'm objecting to. If she is accurate in what her representation is,
she is
I will
accurate.
withdraw my objection. I just need to see the document.
Somebody walk the thing over there and let him read it.
Yeah, read it.
I mean, get to the bottom of this quickly. We'll hold on your vote, Mr. Ogles.
Print out the documents and airplane that right into his face over there. The documents are out there. We've got them on watcherlodge.com, Dan. Go check it out. And it's not just Pam Bondi's statements. It's the actual documents where they found him twice.
Mr. Chairman, given that this is a tweet from the Attorney General that is effectively, I believe, consistent with what Ms. Taylor Greene says, I withdraw my objection.
Gentleman withdraws his objection. I now recognize...
All right, get it admitted. So the whole thing is just a joke. So Dan Goldman fighting for the gangbangers as per usual. And there was more. We got Stinky Eric Swalwell, who is sitting next to Fishing Benny Thompson's side back in this ridiculous committee. We remember Eric Swalwell, who made Bang Bang with Fang Fang, a Chinese spy, and then stunk up the camera during that one interview that time. And now he's bringing out this photo again, and he's going to try to rub everyone's noses in this. And, well, what's going on with this photo? Is it a label? Is that a tattoo? What's happening? Does Trump know what he's talking about? Here is this exchange with Kristi Noem, who is in there answering questions.
Job. And so I want to put to rest this question about Mr. Garcia in this photo that the president posted on April 21. Madam Secretary, you agree that the letters MS and the number 13 in Times Roman numeral font, that they are doctored on this photo, right?
Congressman Abrego Garcia.
No, I'm just asking about this photo.
It wasn't based off of tattoos. It was based off an entire case.
And I'll accept that
case against him.
for the purpose of this question. You agree, though, that this is doctored. Is that right?
The same protocols
Doctored?
that are
Madam
applied
Secretary,
to every
I want you to have
individual with
credibility,
law
and
enforcement.
I want you to be taken seriously. Is this doctored or is it not
Sir,
doctored?
I am taken quite seriously
Is it
because
doctored
I approach
or
my
not
job
doctored?
with the importance that the president has given me to do
I understand.
my job.
Is it doctored or not
One thing
doctored?
that's important to remember is that every single time a case is built,
Madam Secretary,
against
I have a
individuals,
7-year-old,
the
a
same
6-year-old, and a
protocols.
3-year-old. I have a bullshit detector. I'm just
With
asking
Fang
you,
Fang?
is this doctored or not
Are they
doctored?
Chinese?
Sir, the protocols in the case built against
Can you
Abrego
answer the
Garcia
question?
were exactly the same.
Madam Secretary,
I don't have
you're-
any knowledge as to that photo you're pointing to.
Okay. Can you
I
take
don't,
her?
sir.
Can you show her the photo? Walk her the photo down there. No, that one.
Walk it down there?
Please take a look at this photo. It was tweeted
She
by the
can see it
president
from your
on
little
April
stupid
21.
podium
It's
there.
been hanging out there for about a month.
So what is your point?
My question is the numbers and the letter MS-13. Could you look at the photo, please? It's right in front of
Are
you.
you saying Abrego Garcia is not a wife
No,
beater?
no, ma'am.
That he's not a criminal.
Ma'am,
He's not a human
you,
trafficker, and
ma'am,
he's not a
you,
member of MS.
you vouched for Mr. Garcia when
You're
your
vouching
team
for
said,
a man
ma'am, you
that
vouched
is a
for him when
known
you said he was
violent
mistakenly
criminal.
deported.
Sir,
I didn't vouch for him.
I did not say
In that
he
photo,
should have been deported. Absolutely.
It's so
There was
telling
never
that
a
you
mistake
won't look at the
deport him,
photo.
and we will not be bringing
Was
him
it
back to
doctored
Yeah,
or
punk.
not?
in staying here.
Can you look to your right at the photo in front of you? Madam Secretary.
Absolutely. Wanting to spend all the time in the world on the photo because they can't understand it's a label, and he says it's doctored, like it's some sort of scam that we're trying to pull the wool over everyone's eyes, that Kilmar Abrego is just a Maryland man. And they're still sticking on this case because they just cannot let it go, because I think that is their entire constituency. And so we've been waiting to see what was going on in the Kilmar Abrego case in particular. And we saw yesterday that there was a motion to seal filed by Kristi Noem. Haven't seen anything else come out of that, but we had another notice of appearance come in today on behalf of the Trump administration, and that's what's happening there. Now, I will note this too, that even our friends in the UK apparently are getting people out of their country. This was a pretty funny post I thought was relevant to what we're talking about. Keir Starmer said, I am also returning over 24,000 people who have no right to be here, and I won't stop there. We're all asking, like, did he come over here and like drink some of Trump's water or something? What the hell happened with him over there? Now, we have some UK friends who say, don't believe this dude for a second, but it's interesting to see there's a little bit of an effort, a momentum across the country and the world now to take back control of your nation, because they're our nations. We have a heritage, we have a lineage here, and we want to preserve our countries. Here is Kristi Noem talking through some of this with Jesse Waters on Fox News, posting this saying, members of Congress, by the way, are not above the law. So if this fang, fang, bang, bang person or any of the other Congress people who want to use their big bellies to go in here and fight on behalf of the illegals who are detained in ICE facilities, there will be repercussions coming for you.
See, what happened last Friday was we had members of Congress assaulting law enforcement officers. They were cooperating with criminals to create criminal acts, and then they're saying that they were providing oversight. This wasn't oversight. This was committing felonies. This was going out and attacking people who stand up for the rule of law, and it was absolutely horrible. I can't believe they act like this and then they defend it. And then they're doing these acts of violence to get people out of detention centers that are rapists, that are murderers, that are people that are foreign terrorist organizations that have been out there victimizing our communities in the United States of America. What are they trying to do? Release these people back into the country so that there can be more Laken Rileys, so there can be more Jocelyn Nungries? I just don't understand what their point is. They have completely lost their minds. They have completely lost their minds.
So you're saying if members of Congress break the law, they're not going to get special treatment. They're going to be treated like any other U.S. citizen. If they break the law, they're going to pay the price.
No one's above the law.
Well, that's up to the Department of Justice. So my job is to follow the law and to make sure that individuals that are in this country illegally face consequences for that, and especially those that have committed criminal acts against the people that live in the United States of America. So the Department of Justice will make those decisions, but I'll tell you what, those ICE officers get up every single day and they love their jobs because they finally get to do their jobs with President Trump in the White House. And the fact that a member of Congress punched them, hit them, body slammed them, and then claimed that they were the victims, it's astounding to me that someone would even vote for someone and put them in a place of leadership when they perpetuate something as hypocritical and as criminal as what these individuals did. So I hope that the rest of the members of the House of Representatives will hold them accountable. They shouldn't be allowed to be on the committees that they're on. In fact, one of them is supposed to be conducting oversight over ICE, and instead she's assaulting them, and they don't deserve to be in the House. They should be censured by it. It's what's happening in this country and what agendas the Democrats are embracing is absurd, and it's not American. And I'm hoping that the American people recognize it and hold them accountable for what they're doing for criminal acts against people in this country.
Big belly congresswomen barreling through ICE agents on behalf of illegals in America. And if that continues, there will be repercussions courtesy of the DOJ, says Kristi Noem. So we'll be here covering this one. We'll see if Bang Bang Swalwell and the rest of them continue their fight for the terrorists. Thank you for subscribing and joining as we do. All right, we've got more to get to here. And this one is getting fun. Judge Dugan is back, and she says she's above the law. She submitted this motion to dismiss, and inside, she's claiming immunity, judicial immunity. You remember Judge Hannah C. Dugan, a.k.a. Backdoor Dugan, who used her back door to get an illegal alien out of her courtroom, even though there were victims sitting in her courtroom waiting for their case to be heard. She adjourned the whole thing and escaped him from the agents who were there to conduct an arrest. Now, she submitted this motion to dismiss, and this comes after a new indictment dropped against her. So if you look at the docket with Dugan, remember that some time ago, she got a criminal complaint that was filed against her. And we read through that in detail and went through the entire ordeal, the saga, right? She went out, diverted the agents in the hallway back into the judge's chambers of the chief judge, and then basically adjourned the case, continued everything out, and took him out the back door. They tracked him down about 22 minutes later and arrested him. But the complaint, which was filed back on April 24th, is just from a special agent of the FBI. Today, we got the indictment that has now dropped. And the indictment, yesterday rather, is for the same charges, for the same crimes, same counts. Nothing has changed, but it's now been rubber stamped by a grand jury, right? A jury of people that is conducted in secret, where prosecutors present evidence to them and they make the decision that there's probable cause for charges to move forward. And it provides different defenses. And essentially what it's doing is it's confirming that there's probable cause here by an independent jury of peers. It's not just some FBI special agent who's making this judgment. And so if you recall, we saw what the charges were. And once again, in this 2-page indictment, very short, we've got same violations here. Concealment of a person. There was a valid warrant for this person, and she tried to prevent discovery and arrest of this person. That's count 1. And then we had count 2, same violation. These were the acts that would impede the proper administration of justice and the law. And what we saw is she did essentially 5 things. 1, she contacted the ICE agents and she told them, you got to get a judicial warrant before you conduct an arrest. That's not true. Don't need that. You just need the administrative warrant. Upon learning that they were there for the arrest, she asked them and directed the task force to leave the location and to go to the judge's office, right? Diverting them to a different location. She then also addressed the case off the record. So she postponed it, adjourned it, didn't tell the prosecutor who's sitting there waiting for his case to be called, didn't tell the victims. Everybody sat around, wait. And the case is called. And this dude got ejected from the courtroom, snuck out her back door. Then also directed the illegal and his lawyer to exit the courtroom through her back door, and then advised the counsel that they could appear by Zoom for the next court date. Now, again, other citizens who are defendants, they don't get to suddenly appear by Zoom, and the judge doesn't help them escape prosecution from other state prosecutors or federal prosecutors. So as we see here, the illegals, they get more benefits than you do. They don't get arrested when they're trafficking 8 humans in their truck. They don't get their car impounded when they're driving on a suspended, revoked, or canceled license like you do. He didn't get a ticket, Kilmar, for not having insurance. They just let him go because they get more privileges than you and me. And now this guy can just show up to Zoom. Well, everybody else has to come in there and go through security and sit in their courtroom and have their cases called. And now the victims get abused too because they get more privileges than even citizens do. They get due process premium in America because they're more important than citizens according to certain judges. So that was the indictment. Now, what happened is this judge is playing hard, very hard. And take a look at all of these attorneys who are coming in on her behalf. Here you see this one. Stephen M. Biskubik coming in, retained counsel. He's just one. That was another NOA for him. Here's another one. Nicole Masnika is coming in. Hired this dude, Jacek Lukzak. Hired this woman or dude, Dean A. Strang. Hired this guy, John Bradley. Also, Randall Resch came in. And William Edward Graw. All coming in on this case. Amazing. So she's like not playing. And she already hired a bunch of other attorneys in the first place. So boom, right? Filing. She's putting together a dream team of defense lawyers to help her escape her criminality. And they're not waiting around. They already filed a motion to dismiss. And here is what it looks like. Backdoor Judge Dugan now submitting a motion to dismiss because she says she is above the law. She's got judicial immunity. Now, here's what they write. They say, all right, Judge Dugan, Backdoor Dugan, moves for an order dismissing the indictment that we just looked at. Said this is no ordinary criminal case, and Dugan is no ordinary criminal defendant. This is going to be rich because these are the same people who lectured us when we said, you think you can prosecute a sitting president And they said, well, he's just like a regular citizen. There's no difference for him at all. What's your problem? And now they're going to use that same argument. Wait, she's a judge and you can't come after a judge. They say she's a circuit judge. She's above the law. She's better than you. She was arrested and indicted for actions allegedly taken in and in the immediate vicinity of her courtroom, involving a person appearing before her as a party. Now, the government's prosecution of Dugin is virtually unprecedented, and they say it's entirely unconstitutional. I wonder, is there precedent for judges siphoning illegals out her back door? They say it violates the 10th Amendment and the fundamental principles of federalism and comity reflected in that amendment. And comity is this idea of like friendship between the courts. You're not supposed to be attacking other branches, which is wild, watching all of the federal judges attack the executive branch and by that attack, us every day. She says this is reflected in the 10th Amendment and the U.S. Constitution. Hilarious. They suddenly care about the Constitution when she just helped an illegal violate our Constitution and beat other people in our country. Saying, the problems with this prosecution are legion, but most immediately, the government cannot prosecute Dugin because she is entitled to judicial immunity for her official acts. It's the same argument Trump was making. Judicial immunity for her official acts. She's allowed to take people out her back door. Now, immunity is not a defense to the prosecution to be determined later. It's an absolute bar to the prosecution at the outset, referencing the Trump case from the Supreme Court. Incredible. Now, Dugin reserves her right to seek other relief, including by other motions and at trial, but the immunity and the federalism issues must be resolved swiftly because the government has no basis in the law to prosecute her, which is interesting because they prosecuted Trump. Now, the prosecution against her is barred. The court should dismiss this and grant her relief. The judge says she's above the law by committing obstruction of justice openly in her court because it's official. Now, in this indictment, they say she's charged with concealing an illegal from arrest and for obstruction for actions she took in and near her courtroom. Now, the alleged conduct ranges from directing the people's movement in and around the courtroom to advising a party that he could appear remotely to his next hearing. Now, the complaint alleges a more cohesive story, right? We read through that before in a prior video. In pertinent part, it alleges the following. On Good Friday, nonetheless, April 18th, Dugin was presiding over the misdemeanor docket in the courthouse. Many defendants were in the courtroom that day. This is Dugin's team writing, saying agents arrived in the courthouse to execute an arrest warrant for Flores the illegal. A deputy in the courtroom claimed that Dugin directed Flores to leave through her back door. Flores emerged from a doorway into the same public hallway a few feet from the judge's doors. Law enforcement saw him, followed him to the elevator, followed him outside of the courthouse, and arrested him after a foot chase as he was trying to evade law. Now, even if they say, and the evidence is not going to show this, even if Judge Dugin took the actions that you claim, these were judicial acts for which she has absolute immunity from criminal prosecution. Judges are empowered to maintain control over their courtrooms and their courthouse generally, and the issuance of an order removing persons from the courthouse in the interest of maintaining control is something she's allowed to do. Now, her subjective motivations are irrelevant to immunity. The fact that she wanted to help an illegal evade arrest doesn't matter. She's still immune. Judges are entitled to absolute immunity for judicial acts without regard to the motive with which those acts are performed, right? So if it's helping an illegal, doesn't matter. Since at least the early 17th century in England and carried on through common law, they say it's literal absolute immunity for official acts with a few exceptions that are not applicable here. And you remember in the Trump case, really the Supreme Court gave us those three buckets, remember? One, the president is entitled to absolute immunity. It's like, and if the Constitution says he can do it, then he can do those things. You can't prosecute him for those because he's allowed to do it by the law. In the second bucket, we had a presumption of immunity. Remember that like kind of middle bucket? If it's like even within the outer perimeter of the presidential duties, you can consider that to be presumptively immune. And then they had the other final bucket, which was just not immune conduct. if it falls outside of the official duties, and none of Trump's stuff fell outside of the official duties. Ultimately, those cases were resolved for other reasons, ultimately. But the judge, of course, you would argue, would be in that third bucket, would be in acting in ways that are outside of the scope of her conduct, in this case, committing an open crime in violation of what the federal agents had already notified her they were there to achieve. Dugan, therefore, they write, has both immunity from conviction and immunity from prosecution. The essence of immunity is that the person they're entitled to it, and they don't have to go through the process. But we recall Trump had to go through the process in both of those cases. And the Jack Smith case was ultimately resolved because he's not even a real prosecutor, if you remember. So Congress did not abrogate this common law immunity. She still has it. And they enacted other provisions with an express focus on unconstitutional behavior of even judges, and said that this immunity is a bedrock principle. Now, it's doubtful that Congress's Article I powers would extend to criminalizing state court judges in their own courtrooms. Criminalizing the official acts of a state judge controlling her courtroom would implicate all the concern, but that's not what that was, right? It wasn't just controlling her courtroom. She was committing a new crime. And nothing in this indictment alleges any violations of a person's constitutional rights that implicate the concerns of the amendments. And the court need not consider whether Congress could have done that. And so this is even worse. Immunities aside, this is about federalism. Federal power should not be coming in and attacking state judges. The states have police power. The federal government doesn't have it. And the American judicial system is mostly the criminal cases. 99.4% of them are filed in the state courts. And so the government's prosecution here from the feds reaches directly into a state courthouse. It's disrupting active proceedings. No, it wasn't. She was disrupting the proceedings. They were waiting outside. They say it interferes with her duties. No, it doesn't. They were going to wait until the hearing was over. A state defines itself as sovereign. Judge Dugan was elected by the people, and they violated the state's sovereignty by coming in there and interfering with her escape plan. Now, as a practical matter, counsel for Dugan stand ready to file briefs to participate in an evidentiary hearing if you want to. But you should dismiss this right now. And in the event the prosecution moves forward, Dugan reserves her right to expand all of this in our motion to dismiss, signed by her entire team of lawyers, all listed there. Strang, Bradley, and others. So Dugan, I am above the law. I can commit open crimes, obstruct justice inside my courtroom because I'm a judge. And there's nothing you can do about it if you're the federal government. And obviously, the Supreme Court precedent, I don't think, is in their favor. Yeah, they'll have some immunity as a judge, no doubt about it. But when you go outside into that third bucket, just like Trump's argument was, the Supreme Court said if you're in that third bucket, you're outside of immunity. And we had to have hearings and more on that. But obviously, those cases ultimately were dismissed. So, Backdoor Dugan, fighting for another day. She's got an entire team of lawyers coming out on this one. Of course, the Trump administration will respond to this. They'll issue their response. We'll read through the response and we'll see what they say. But I don't think the motion is going to be successful. By and large, motions to dismiss at a stage like this are almost universally denied, just as a matter of practicality. By the numbers, it's likely going to be denied. But Trump will issue a response, a reply. This is a grand jury indictment, and it's likely going to proceed to the next stages, but she is fighting hard. We're going to be here covering it. Thanks for subscribing and joining as we do. All right, so good updates there. Now let's talk about this weird dude and his impeachment madness. This guy's kind of nuts. Democrats are embarrassing themselves now trying to impeach Trump. We've been wondering when they were going to do it. They keep calling him this person who's wrecking American democracy and undermining our constitutional order, blah, blah, blah. Will they do something about it? Well, now this guy has, and he has a hard time speaking English because he wasn't born in our country, now wants to use a Trump impeachment effort to raise funds for himself. But he came out and he published today his articles of impeachment. I'll show you just quickly what they are and show you how I think the Republicans are actually taking glee in this, because this guy is such a bad advocate for the Democrats. it can only help the Republicans and the right. And in fact, this guy knows that his impeachment articles are crap. Here's what he said. He says, my articles aren't really a piece of crap at all. They're actually pretty good. Here's what he says.
Nobody has said to me, Mr. Tanadar, the 7 articles of impeachment that you presented to the U.S. Congress, they're piece of shit. You know, they're not.
They are.
You missed the point. They're not legally right. He didn't do that. No one says that.
Yeah, we're all saying that. Even the Democrats are not happy. They're kind of walking away from this guy. They're like, Shri who? Who? From what state? No, we don't know anything about that guy, because it's like perfect. The Republicans like, yeah, no, put him at the top. It's like, we want more of this guy. We want more of Jasmine Crockett. Huge fans of her. We think these two should probably run together on a ticket the next cycle. Be great for all of us and the Democratic Party. So he also got scolded by Marjorie Taylor Greene, said, you know, this guy, Shri, is the same guy who abused beagles and abandoned them to die when his testing lab got shut down. He's going to force an impeachment vote on President Trump. Says the Democrats should be so proud to be led by a guy who eliminated beagles. So fitting. Says this thing's dead on arrival, so don't even worry about it. So he was out there filing articles. I think there is some serious concern about his financial affairs, and he might need some of that money to get his house back in order. But I came across this clip. This is how bad this dude is. Doesn't even know his constituency at all. This guy asked him a question. Can you describe to us who you represent? Like, who's in your district? Can you even say who they are? Here is what he sounded like.
I don't know. What are the 5 Grosse Points cities? Well, look, I'm not here to answer a quiz. I'm here to say that I'm going to fight for the people of Detroit. I'm going to fight for my constituents. And all of the Grosse Points and all of Taylor and every part of the 13th district. I'm just do this real quick. Grosse Pointe Park, Grosse Pointe Woods, Grosse Pointe Farms, and Grosse Pointe Shores. Okay. You know, on your campaign filings, it says occupation. Yours says United States government. Aren't you employed by the people of the United States? Yeah, I am. Okay, you fix that one. Okay, and finally, you're getting nailed with this one. The beagles. You abandoned the beagles, left them to die in their cages at your pharmaceutical testing. See, look, I don't know.
Yeah. So that's that guy having a tough time out there, now trying to impeach the president. He is, I think, going to have a hard time on this one, but he did submit his articles of impeachment, and they are crap, as you can see here. They're 29 pages. And he's going through a big litany saying that Trump is basically abusing his office, saying, using the power of his office, Trump has engaged in this scheme and course of conduct to subvert the constitutional duty, it's like meaningless, of the United States. And now he's purging career employees of the DOJ. Amazing. That was so awesome when he did that. He also removed people to El Salvador. That was amazing too. We covered that every day. It's awesome. Kilmar Abrego, wife beater Garcia, gone. Absolutely awesome and outstanding. This is awesome. Defied court orders. No, he didn't, you liar. Facilitate the release. Yeah, read the rest of that opinion. Acted in contempt for violating a settlement agreement for what? And conduct enforced disappearances of persons without due process and more, right? Eliminating inspector generals, doing a bunch of amazing things. And so he's usurping the powers of the presidency, and he must pay the consequences for this. But he's not getting a lot of favor on this. They say this is going to be a long shot. He is going to force this basically solo. He started the clock to vote on the 7 articles of impeachment against Trump. Republicans are going to kill this, obviously. But then it's going to force the Democrats into a tough position on a vote many of them don't want to take. His move forces the House to take action by the end of the week unless he withdraws this. Spokespeople for Johnson and Hakeem didn't talk about it. 29 pages, mostly a ranting screed. He told Axios, well, there's some communication with Democrat leadership, but I didn't seek their permission. I just did it because he's got to make some money. But the Democrats got asked about this today, and here was a little bit of that exchange.
Questions? Nick?
I understand leadership is going to vote to table Congressman Thanadar's impeachment resolution today. Does leadership also plan to do so with Congressman Al Greene's impeachment resolution?
Well, resolutions, in order to be to force a vote, resolutions of privilege have to be ready, and the individual, the maker of the motion, has to go to the floor and ask for that. We will deal with what is being offered this week. I have said before from this podium that this is not the right approach we should be taking. We'll join members of the leadership team in voting to table that motion. Right now, our focus is on health care being stripped away from the American people. That is the most urgent and dire thing that we could be talking about this week. Everything else is a distraction. Andrew?
Oh yeah, that was gonna be my question.
That's it. That's all you got?
Can I follow up?
Michael, then.
I actually have a question for Mr. Liu this week.
All right, so not a lot of enthusiasm for that, and I think they know why. It's not going to be a victory for them. House GOP will continue to, I think, enjoy this. They should promote it. Trump's under attack for the Democrats. Look who their standard bearers are. Sri Thanadar from India and Jasmine Crockett from Texas says Democrats are already trying to impeach Trump. Totally political, very not serious. But what do you expect? Not much. They are the Democrats after all. And so, my friends, it has been a beautiful stream. Thank you for being here. If you're just joining us, quick recap. We covered 4 good segments today. And if you're looking for any Diddy activity, check out Good Logic, Joe right next door on the YouTubes and everywhere else. He's covering that case amazingly well. So check that out. We also want to remind you of what we did today. So this at the start of the stream, we talked about the Alien Enemies Act and had a very nice victory. So definitely make sure you catch this if you missed it. Western District of Pennsylvania, 43-page decision in favor of Trump, saying the proclamation invoking the AEA is perfectly valid and legitimate, and there's nothing wrong with it. So the deportations are valid. Did modify it a little bit, said a little bit more notice, but otherwise, the deportations should be able to continue. Now, there's a bunch of competing cases, so the legality is still complex, but a checkbox in the victory column for our side. We then talked about Marjorie Taylor Greene getting into it with Dan Goldman and the rest of Congress, which was pretty fun. We saw Stinky Eric Swalwell, who made Bang Bang with Fang Fang, a Chinese spy, got into it with Kristi Noem. And more reaction from Benny Thompson, Keir Starmer, and quick updates on the Kilmar case. Then we got the latest on Judge Dugan, Backdoor Dugan. She got done lecturing us for 4 years, saying no one's above the law and that immunity doesn't apply to anybody anywhere, even though we know it does. So we'll see how that goes. And I think that there is some, there are going to be some interesting and novel arguments on this. Like, where is the line? We talked about this morning with Economath. Where is the line on the Dugan stuff? Where does the protection limit? Is it in physically, geographically her courtroom? Is it the courthouse? Who holds the privilege? Is Dugan privileged? Can somebody who's traveling to the court facility invoke a privilege against arrest, like Economath was saying? Or does that privilege apply to Dugan? Can she invoke a privilege on his behalf and claim she's protecting his privileges and obstruct that in that basis? Could be an argument. This judicial immunity argument is going to be fun. So this will be an interesting case to cover. We'll be here on it. We also then talked about Sri Thanadar, who, of course, is the congressperson who's impeaching the president, and the Democrats seemingly want nothing to do with any of it. But now, my friends, it is time to hear from you. And it's a beautiful day. How was the stream today? I'm seeing a couple of YouTube just glitched. Let's see what's going on. We're keeping an eye on this stuff. Do I have any dropped frames over here? It says 0 dropped frames on my end. 11% CPU, 30 FPS. Only glitchy, someone says, only glitch for a second on mine. An occasional glitch is, I think, just the nature of streaming land, but hopefully it was good and clear and clean. Anyways, my friends, thanks for being here. Thanks for all these amazing donos. Thanks for supporting our work on the day. And now it's time to hear from you. Thanks for joining us. Let's see who's joining us over on the Telegram, which is where our amazing mods and meme smiths are clipping away for us, keeping things nice and orderly around here. We're grateful. We had a bunch of new membos coming in today, too. Woo, we're going to welcome them in. Clark, thank you for that. Hey, it's Wednesday. Wednesday is here. Happy hump day indeed. Thanks for saying that. What's going on? Sharon Sunshine bringing in Lily Von Stoop in the house. Welcome, Lily. And thank you, Sharon, for bringing in Lily. We got this one from Greer. Harold Greer is bringing in 5 new friends. Harold. Amazing. 99.99% uptime. We like it. Amazing. Harold Greer bringing in K-Jab. John, what's up? Arcantos in the house. We got Joe Holloway. The Mangeese is joining us. Very nice to see you. Thank you, Harold, for bringing them in. James Marino, what's up, James? Thank you for upgrading your membership to shout out membership, and I appreciate that. What's up? Anthony Stokes. Great to see you, Anthony. We'll see you on the members only stream tomorrow, too. Turd Ferguson says, if only I could explain this as well as you can, bro. And I like how you said can, bro, because that's kind of like a conjunctive word. I appreciate that. Thank you, Turd. Hey, Londo. Rob, you need to use this router. It allows the use of 2 internet providers like Cox and Starlink. I have one of those to share the inbound, outbound traffic so you don't have a single point of communication failures. IP and MACs are partially deleted. I do have a multi-WAN. It looks exactly like that, and I really couldn't get it configured to work well in my old location. But my new system, I haven't set it up yet, but it actually has backup. So my new router system, I can hook up a backup Wi-Fi to that, which I'm going to do. So it's a great suggestion. Chubby, can't just this administration a clearly correct ruling without adding some BS concession for the left? Court's got to flex its coup power still, Chubby. Yes, well, she's like, okay, I guess I'll let them win, but I'm still going to give you a consolation prize. Here's a little ribbon. You get more notice. I see what you're saying, Chubby. Funny. Bobsco, what's up? Tanya Hammock gifted a membo courtesy of Bobsco. Thanks, Bobsco. Welcome, Tanya. Doan says the Human Rights Foundation condemned Nicolas Maduro for using TDA to locate and assassinate dissidents beyond the Venezuelan borders. Wow. Yeah, so it's not just the American government who's making this determination. There's also other entities that are doing the same. Clark Blount in the house, bringing in a bunch of new membos. Thank you, Clark. What's up? Wednesday Snow, Arbitrary Objections, Sue's Daily. What's up, Celia Frostborn? BJ008. We got Darkchild Williams, R. Farrell, Generic Screen Name, Warren Moffat. We got Jets, Gary Haynes. Welcome aboard, Nicholas H. FKN Cuckoo is here. We got Marcia St. Nick, Poppy Cats, Donetta Swift, Lunzatis Pale Moon is here. Kata Lee, we got Wonder Bucket, and Stephen Richards. Clark Blount bringing in more. Riri is here. We got Vader Mike, David Sweet, Suits, Janelle Rella. We got Karma Plushy, Transor, Omar Ramos. What's up if you know me? Chip Edwards, Joe Kukula. Plus 50 more from Clark. Thank you. What's up? Welcome, 50 new friends. Beverly Manseth, Truckin' Bear. We got Andrew Kubileski, the W2 Report, Greg Chef Antonio. Helix is here. Totally Jacked Up. Gavin Patterson, CJM, Dustin Buck, Tone Jack, Corey Steegs, Mama Bear, Tom Nardone. We got Sagi, Chris Friday, 3D Slug, C Fox, Ham Cons O. We got B Jacobs, Barbara Norton, Mixters here. Asara Nesu Amun Rebe. What's up, Dick Tracy? Boxer Heather, Curtis, Sir Brother Thomas, Just Peas Girl, William Carter. What's up, Rudy Terrata, Bull Puppy, Vin Man, Patrick Phillips, and Cheer, along with Jeff Stout, Paul Keir, Mike DeSalvo, Garbage Man Stacking, Dant, Lori Anderson, Bender the Robot, Michael Crandall, Dog Mom, Missy, Terry Edwards, Rooster Raptor, Army P-Man, Sean Quinn, Nightman's Wife, Matthew Fat Man Flying Cox, Gifted Membos, and Clark is keeping them coming. Clark, thank you. What's up? JWD. We got Krista J. Helter Skelp. What's up, Todd Ferris? Nikki G. Bear Arms. We got Steve. Dion Hayes. What's up, Scooter? Ronnie Phillips. Boston Dottie of Instagram. David Cox. Hev MC. Checkman. We got Smokestack Lightning. Expert Wings. Texas Granny. 392 Hemi. Linda Drake. And JJ, Gifted Membos, but not done yet. Clark's also bringing in Tammy K. What's up, Jill Moore? Michelle Christov. We got Kevin Var, Yurter. We got Colin Landrum, Wilma, and Gigi Katz, gifted courtesy of Clark Blount in the house. Clark, that's a lot of membo, friends. Thanks for doing that. Welcome aboard. We'll see you tomorrow, everybody. And grab the members only stream from this morning and say thanks to Clark for bringing you in. Doan says, hey, what's your call on HR 1526 passing in the Senate? It's a great question, Doan. What's HR 1526? Unlikely is my guess, but I don't know what it is. Hey, Clark, what's up? Ron Webb is coming in. Clark, you're amazing. Baggy, SW Mom's audiobook is here. Eduardo, Yorktown, Bedtime Stories with Grandpa Sam. We got Sodium X, Drop Bear, Catman. What's up, Dabson Glass? Gail C, Timothy Locobachi. We got Scott Ling, that guy. Brian Leffler. Jeff is here. David, 310 Flyer, Catherine Steffi, and Dexter Monk. Gifted membos, courtesy of Clark Blount in the house. Thank you, Clark. We appreciate you. What's up, Rick D? Says Dugan has filed a motion to dismiss. Man, Rick D breaking the news at the same time as we're covering the stories, baby. Fresh out of the oven. Thank you, Rick. Rick's got the sources of the links out there. Doan, what's up? Asymmetrical warfare must be included in the TDA convo. Yeah, and I think, the judge didn't have had the foresight not to substitute her own judgments for those things and just default to what Trump said, and he checked the boxes. That's all you can do. Alice Elizabeth says, here's a question about Dugan. If a judge decided to help a person escape before their court to escape before a trial, just that, no ICE involvement at all, what would that be? In other words, you read why the guy was there, attacking 3 different people, even strangling one. If the charge was simply that she helped him escape before a trial, is that a felony? Material for being disbarred? Yeah, I mean, my argument would be, it would be outside of judicial immunity. Like, she can't do whatever she wants, like in her courtroom. Like, she can't just shoot somebody in the face in her courtroom and say she's a judge. She's committing a crime. Like, the feds wanted this person. It was obstruction. There's certain immunity that she has, but when she crosses that line, she loses immunity and she can be prosecuted. And it'll be curious to see what the standard looks like and how that all applies. But yeah, I mean, what if, to extend your hypothetical, what if she has a jury trial in her courtroom and the jury says that illegal is going to prison for 10 years, convicted, it's mandatory minimum 10 years. She has no choice. Does she help him escape? Does she create a new fleeing felon because she doesn't want him to get picked up by ICE? Because as soon as he gets taken into custody, ICE will put a detainer on him and then transfer. So would she escape him if he was convicted but not charged? And is she allowed to do that? And if that judge is allowed to do that, can't every judge in the country just do whatever they want in their courtroom if they have unlimited blanket immunity that can't be challenged? Clearly ridiculous. Matt Ostrander, what's up? I missed the first baby. Guess I'll try again at number 2. We were wondering where that kid came from. It's yours, Matt? Well, thanks for claiming it. Missed the first one. We'll catch you on round 2 because I hope you're going to be here that time. Lots of time together. We appreciate you. Thank you, Matt. Hey, Sheila Pooh. I love that we have at least one sane judge. I know it feels good every now and then when we get one. It's like, wow, they're arguing, they're writing their opinions and their orders in a way that you would expect a judge to write with due deference to a co-equal branch of government. Sheila Pooh. Hey, 15 months, Sheila, getting closer to baby number 2. We can't wait for a whole nother baby. It's going to be fun. Thank you, Sheila, for being here 15 months. It's a long time. Chubby. I know it would never hold up in court, but I'd love to see ICE and the DOJ say that the proffer to self-deport they made to all public counts as notification for all illegals. I can just imagine the uproar and the meltdown on the left. Yeah, I think that's right. They're very upset about a lot of these decisions. And they did get notice. I mean, Trump, they should have had notice as of January 20th. Like, Trump gave them notice before the election and after the election. Like, they should have known actually since November, right? Once we knew that Trump was going to win, like, should have been packing their bags way back then. Sharpie guy, hey, what's up? I'm happy you're deferring Diddy's judicial proceedings to good logic. I had to skip out. It's so disturbing. It's disgusting. Yeah, it is disgusting. And it's very gratuitous. I think this one's even more gratuitous than the Galin case was. Yeah. Doan, what's up? Kilmar remains in CCOT because he's MS-13. Dan. Goldman. Yeah. Hey, what's going on? Hey, rub some dirt on it, says, who's Galaxy Whirlpool says, there is no such thing as a declaration of gang membership. That's what I'm asking. It's like, you want a trial to declare he's a gangbanger? He's already been adjudicated that. That's part of the reason he's being removed. Sheila Poo says, why, yes, indeed, it was a court order, Dan, because he was found to be reliable that he was MS-13. He was deemed by an immigration judge to be removable to anywhere but to Guatemala. You nailed it, Sheila. That's exactly right. Yeah, and the removability withholding was because of mom and papusa business in Guatemala. But Dan, I think, is still stuck on Maryland man. Like, he probably still thinks he's a Maryland man or something. And somebody should just show him the order. It's right here. Read it. Kevin G. Thank you, Kevin, for becoming a supporter. Grab the stream from this morning, the Membo stream. We'll see you tomorrow, 12 noon Eastern on the Membo stream. Fred Pedamonte says there's a new Schiff in town. That is for sure. And Rebellious is here. Great to see you, Rebellious. Clark says bad Republicans need to be voted out. Definitely. Especially Tom Tillis. He's terrible. NY says great sensible decision by the judge who knows the limits of the judiciary and about separations of powers. The Constitution doesn't mention co-equal. The liberal talking point is easily dispensed. This liberal talking point. We have judicial review. Certain powers have little or no check based necessarily. Yeah, I mean, I guess co-equal, you would say, I think co-equal is a reference to the idea that no one's in charge of the other, per se, right? So, like, you don't get to tell me what to do. So they're all on the same operational playing field. But you're right in terms of power and checks and balances. And many would say that the judiciary is the least powerful because that's all they have is judicial review, which is relying upon their credibility and their legitimacy, which I think is by design. Because the founders were very skeptical of a powerful judiciary doing exactly what they're doing today, essentially. Hey, G-Men says, it's an annotation. It's not doctored. Yeah, you see how they conjugate the language, right? Like, they went home versus they fled the scene. Both are the same action. It's just conjugated differently to convey a different meaning. It's annotated. It's labeled. It's an identifying mark. It's not doctored. Dan. Anyone with a brain understood why those letters and numbers were added to explain why that set of tattoos were indicative that Garcia was MS-13. Yeah, and they want to just say it's fake. It's not real. Like, it doesn't represent the tattoos. Not that bright. Hey, Rebellious 1776 says, Dan Goldman, proud graduate of Levi Strauss School of Law. That's why he can't read a court order, because he got too much money from his daddy. He's an heir to the Levi Strauss Gene Company and has really parlayed that into a congressional seat. Hey, Pinochet's helicopter tours, most exciting helicopter ride you've ever been on, says district court judge uses John Roberts' quote against him, saying members of this court are vested with the authority to interpret the law. We possess neither the expertise nor the prerogative to make policy judgments. Those decisions are entrusted to our nation's elected leaders who can be thrown out of office if the people disagree with them. It's not our job to protect the people from the consequences of their political choices. Roberts said that in 3 parts. That's exactly right. Yeah, they don't get to, like, they say, well, this is really harmful to all these people who are going to lose their jobs. We say, we know, we considered those consequences, and quite frankly, we don't care. This is what we got elected to do. And the judges stop it all, right? Against our will. They're not allowed to do that. Tobo, I think the photo of Kilmar's hand is genuine, but the letters and numbers are added as interpretations of the tattoos below. The stenography is old art used to convey messages in secret. M is for marijuana, smiley faces for S. It's not the decisive evidence that he's MS-13, of course. No, I'd say alone it's not, but there's a bunch of other evidence, and it also looks bad when the spouse is covering it all up with heart emojis on the screen. Yeah, what's up, Doan? Today I heard a Membo in the morning stream say that Tulsi has the toughest job, but Christie's is right up there too. The title can change hands on any given day. I think that's right. Yeah. And, to be fair, I heard, I listened to the full John Roberts interview. He did an interview, I think, 2 days ago with, I think, Georgetown Law. And it was quite good. It was very good. It's always interesting to peer into his brain. He's a pretty reasonable, even-keeled dude. And I still think pretty charismatic and charming. And he told a story about how on the Supreme Court, it's 9 of them, and how they're kind of bonded together because they have to come together and sometimes make decisions on literally who lives and dies. You have to come together and agree or disagree. I'm like, nope, yep, nope. And you can imagine, right? Certain things pop up and it's the pressure. You can almost see the pressure in his face, ugh. And what would you do if you have to adhere to the Constitution, but that might result in some deaths? You're like, ugh. What do you do? Nikki P. Hey, shout out to Robert because that's what a member can do. Thank you, Nikki P. Thanks for being here. 22 months as a member. That's some serious time together. We appreciate you for being here. Doan. I guess Dugan is in the import-export business too. Yeah, exporting people out her back door of her courtroom. Thank you, Doan. Sheila Poo says, it is not an official act to try to smuggle someone with an ICE detainer out her back door. What was she adjudicating with those actions? Nothing, right? How is it different than her selling drugs, shooting somebody, committing other crimes, and more? Jason, Clean Safe Energy says, I want to buy your shirts, but most sizes are small only. Get some 3XL for us tall guys. Is that, are you saying on the YouTubes? Are they? Okay, we can tell her. Is she labeling the smalls? All right, I'll tell Pamela. We're going to get the better sizes up there. Thank you for the heads up. Jason, Clean Safe Energy. Jonah Finn. I hope this case ends judicial immunity forever. At least if it's absolute to her characterization. How can that stand? Pinochet says, yeah, right, but Trump can't use SEAL Team 6 to take revenge on his behalf or sneak people out of courtrooms. Well, I think it would depend on the exercise of the power. If Trump is using SEAL Team 6 because somebody's going to set off a nuke somewhere or something, there might be a justification for that. If she's going to sneak him out of the courtroom in service of the law somehow, and she's protected under the law, I'm open to the argument, but I haven't seen that. G-Men says, why would a judge's immunity at the state level be applicable at the federal level? Well, I think it's just because they were saying that she has immunity that protects her against allegations that are stemming from her power as the judge. So that immunity covers both jurisdictions, essentially. She holds the privilege as the judge, and that is a shield against any allegations of misconduct that emanate from that power. Yeah, and G-Man, thank you for that. Richard White, if the Dugan motion to dismiss was prepared by an elite team, I'd hate to see one from a lesser team. That entire motion was lacking. Yeah, it was pretty short, pretty brief. And it was just, I think, anchoring it in there. We're going to use this Trump defense and get ready for it. Rob says, question, who is paying for Backdoor Dugan's legal defense of all those attorneys? Are they volunteering their time? Good question. We can't tell on that, but it is probably a combination of both, right? She's probably got some volunteers, donations. I'm sure Democrats are funding this out the wazoo. So she's got funds. Sheila Poo says, never trust anyone who smiles like that guy does. He looks crazy. Probably a Democrat. Thank you, Sheila Poo. Not sure who that was. Henry K says, your audio keeps cutting in and out. Well, hopefully that stopped for you, Henry K. I think we were getting good feedback from hopefully most other people. Sorry you had that problem, though. Dan says, I think Rob will be on at 9 a.m. because of the SCOTUS hearing, 10 a.m. tomorrow. Yeah, do you guys want to go early and cover the 14th Amendment case? Starts 10 a.m. tomorrow. Don't know that we'll be going at 9:30 a.m. I think we'll probably just kick it off right at 10 if you guys want to do that. Be an early stream. FD Man says, Congressman Turtlehead with a wig Kumar eliminated Charlie Brown's best friend. Oh, yeah. Yeah, what's up, FD Man? Felix De La Cruz, what's up, says, crooked Judge Dugan helped an IA in her court for assault. Now she's claiming immunity to help him flee for justice? Yeah, that is what she's doing. Thank you, Felix De La Cruz. she says she's above the law. She can do whatever she wants in her courtroom. It's her courtroom. She wants to shoot somebody in the face, she can do it. Mom CEO, it was showing when new members joined. I turned that off in the middle of the stream because it looked like it was a lot. So I think I will turn that feature off, so it's not too distracting. But thank you, Mom CEO, for flagging that. I did turn it off in the middle of the stream. James Kipp, impeach and disbar Dugan for high crimes and misdemeanors. She's literally been charged with felonies. Yeah. But the court has only suspended her, and they have not even suspended her pay. Felix de la Cruz says Congressman Wiggle, Turtlehead Kumar eliminated Snoopy. Terrible. HR 1526 is to limit the authority of the district courts to provide injunctive relief. No Rogue Rulings Act. Oh, well, maybe that'll pass. Yeah, maybe that'll pass. I think that's Darrell Issa's in the House. That's in the Senate now. So that was, I think Grassley was behind that one too. Maybe that'll pass. I would like it to pass rather than not, but yeah, good one. Hey, Felix de la Cruz. The vote on HR 1526, known as the No Rogue Rulings Act, has passed the House. It's been referred to the Senate, and it aims to limit district courts' ability to issue nationwide injunctions ever again. From Felix de la Cruz. Thank you for that, Felix de la Cruz. We appreciate that. And yeah, we'd like to rein in the judiciary. And I'm sure they'll sue and they'll say that act is unconstitutional, and we'll see what the judge does about that. But yeah, it's good stuff. Hey, what's up? It's Jake. Says, Rob, myself, Chuck Schumer, would like to thank everyone watching the glitched YouTube. My Democrat brother and sisters, you are what keeps Chuck going. And there's some pretty disgusting photos of Chuck in a bikini on our Locals. Says, please do not go to Locals, a flawless platform that also gives you bonus content. Stay right here on YouTube, says Jake Sullivan from Oxford. Nancy and Chili's send their love to you guys. Well, we got Chuck Schumer in a bikini over there, courtesy of Jake from Oxford on Locals. Thank you, Jake from Oxford. My eyes will never recover. Felix de la Cruz shared this one, explaining HR 1526 is the No Rogue Judges Act. Thank you for that. And Philip also, man, you guys are great. Thanks for letting me know what it is. HR 561 is another one. Overtime pay tax relief is also working its way through Congress. Philip saying this one came over from Don Bacon from Nebraska, and maybe that's working its way through too. HR 561. Overtime pay tax relief. Nice. Doan, it's the Darrell Issa bill and the ability to infringe on the judges. Thank you for that, Doan. Hey, Felix de la Cruz says P. Diddy's role models are R. Kelly and Epstein. G-Men says, you always hear that the court orders that we read about Kilmar were for bond and not an adjudication. How do you respond to that? Were for bond and not an adjudication? It was an adjudication. I mean, he had his opportunity for a hearing, and the bond was to get out of custody. So we're not going to let him out of custody because he's MS-13. I think it's the same thing. I think they're just trying to be sneaky about that. Like for bond? It's the same thing. They're adjudicating his status to determine whether he's released or not. So you want another hearing? Like what would change in the other hearing? Nothing. I don't even understand really the distinction. Their argument was like it's a bond hearing and it's not a trial. It's a form? Is that what he was saying? Thank you, G-Men. Spuds, Goldman is banking on the illegals because even he knows that more and more people in his district are getting red-pilled. Yeah, I think that they're just hanging on to that, trying to squeeze it for what's left, but it's not, I think, working out for them. And others, even the media, I think, has kind of dropped the Kilmar case. Hey, Felix de la Cruz says something about Jews here. Jews are members of the tribe of Judah. The tribes of Israel, Isaac is the son, and they were called Hebrews. Thank you for that. Michael Stetson, what's up? 2 years, baby. Thank you for being here for 24 months, Michael. We appreciate that. That's a long time. 2 years in the house. We've been together through some serious stuff. Off topic. What's up, Maria? I dreamt I went to D.C. to tour the White House, but found it closed for construction. It was being built out for President Gouveia's kids? Man, that's a wild future there, Maria. Sounds like a wild dream. Thank you for that, for sharing it. Is that a dream or a nightmare? For some people, it's a nightmare. G-Men, but if the immunity was given to her by the state and not the federal government, it doesn't seem like she should be immune in federal court under any circumstance, says G-Men in the House. All right, and so, my friends, thank you for sending those in and for the amazing donos and all of your tremendous support. Let's say hello to our friends on X before we wrap it up on the day. Hey, what's up? Barb Schaefer says, why didn't Backdoor Dugan have the bailiff remove them from the courtroom to detention to legally establish control of her courtroom, right? Isn't that the normal course? Seems like the building's escape hatch back door isn't where her bench is located. Was her gavel a doorstop? From Barb Schaefer. Good to see you, Danny McWilliams. Fred Pedamonte is referencing the Ed Martin interview with Tucker Carlson, which I listened to a highlight of that. I can't wait to hear the rest of that. Jen Griffin, what's up? About time we got a common sense judge. No doubt about that. Nice to see. We don't see that a lot. Hey, Jody says, it's a great show. Things are getting spicy, and I'm planting some ghost peppers and some peach Carolina Reapers. Man, that's crazy. That's hot. Guernica says, I had it with YouTube watching on Rumble from now on, and it's great to see everybody. So, okay, thanks for saying what's up on X, and I'll check the stream to see what else is going on. But my friends, it has been a beautiful stream on this amazing Wednesday. Thank you for being here. Thank you for joining us. Thanks for being amazing supporters, for bringing in new members, for all the support. We will pause it there on the day. Felix Dela says, an immigration bond is a release. IA does not show for the court when the immigration judge will issue a ruling in absentia. If the IA contest, then the BIA make a ruling, and Kilmar got both of those. So Kilmar got both of those. It wasn't like a small proceeding that's like a bond hearing. I think that's their argument. Thank you, Felix. All right, so my friends, great stuff sent in. Thank you for sending those in and for your support of the show. We will pause there for the evening. We're going to end it there on the day. Locals, the stream is probably going to end, but we're going to try to reconnect for the after party. If it doesn't work, I'll see you in the morning tomorrow, but the screen is going to go dark, and then I'm going to restart the feed and see if it connects. If it connects, great. We'll have our after party. But otherwise, my friends, we're going to call it a day. Hey, Philip says, Tim Burchett says they voted on a bill to overturn a bill that funds the Taliban. How is funding the Taliban not treason? Great question, Philip. Yeah, great question. Glad Tim Burchett is asking about that one too. So, my friends, it has been a beautiful stream. Thank you to our amazing mods and meme smiths. Obviously, K-Bean, Donut Mind Me. We got John. We got Janek, Dog Digger. We've got Geegum Geegum, Just Rhonda, Elliot, purveyor of our documents and emojis, and everybody who helps bring this show together. We are grateful for you. And so we will pause right there on the evening, my friends. Of course, tomorrow we are coming back here. We're going to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.